That's good.
Hey, Bombs. No, we're ready. SAP. All right, we're going to go on the record. Court is going to call 2022 CR 1331, State of Texas versus Raymond Alejandro. Could I have parties announced for the record for the state
Travis Banks for the state of Texas.
and else for the state?
Ruben Herrera for the state of Texas.
For the defense?
Matthew Allen.
Ruben Gonzalez.
And are you Mr. Alejandro?
Yes, ma'am.
Are both parties ready to proceed, state?
State's ready.
Defense?
We're ready.
Defense, have you received all the discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. The court has been informed that the following jurors are not here. Juror numbers 13, 15, 58, 68, 71, and 72. Any objections to proceeding without those panel members, state?
No objection from the state.
Defense?
No objection.
All right. They're going to bring, the deputy is going to bring the jurors in. Each side will have 45 minutes. And as previously stated, and Mr. Allen, I know you've been in jury trial with this court before. The objections for cause are not to be done in front of the full panel. That will be taken up after they're excused. All right, Deputy Laura, if you're ready to bring them in.
Yes, sir.
Thank you.
Here.
All right, thank you. All right, everyone, juror number 68 is now present.
Yes, take this on your judge.
All right, thank you.
Everyone is just got here too.
All right, 71 is now present, everyone. So the jurors who are not here are 13, 19, 58, and 72.
They like literally just got here.
Okay, all right, thank you. Yes, we're ready.
All right, the jury. So first row. 1 through 7, first row right here. Let me number. If you don't have a seat on number, hold it in your hands, please. 1 through 7. Number 8, the top row. Right down here.
Someone wanted to do that. So.
Oh, okay. Have a seat where you're talking. Yeah.
And everyone, please don't sit on the cards because those are your numbers. So make sure you have those in your hand.
Don't have to see your number, please. Hold your hand, please.
Diana, how is your pen? Oh, it is.
Don't say your number, please. Please hold it in your hands.
Beautiful on you. My mom always says that we're our own worst critics.
Don't say your numbers, you can hold your numbers in your hand, please. Huh? No, you said. Thank you. Please hold your.
All right, everyone, please be seated.
Your Honor, you had number 13, 68, and 71 committee.
All right, thank you. All right, everyone, good morning. All right, so here's the thing. Yes.
Some of the numbers might be,
Oh, the numbers are,
if they're too off in your head.
the numbers got rotated on us. That's okay. People can get their steps in. All right, good morning, everyone. All right, that's extremely weak. It's Wednesday. It's the beginning of the day. Hopefully everybody had breakfast. Good morning, everyone. Oh, that's awesome. All right. I am Judge Stephanie Boyd. You're in the 187 District Court. It is on the 4th floor of the courthouse. So where are you?
187, District Court.
All right. So everybody is drowning off, sort of like when you're singing Old Lang Syne for New Year's. People know the first words and then everybody just starts mumbling. So what court number are you in? What floor? Who's the judge? All right. And I know what you're probably asking me. Why on earth would she ask us that question and have us repeat it? The reason why I do it is because sometimes we're going to take breaks. And whenever we take a break, everyone, at least all the jurors, have to leave the courtroom. And what ends up happening is sometimes people get lost. I've had jurors say, I looked up and everybody was gone. So I always have people repeat that because in this courthouse, there's only 187 District Court. So if you ever get lost, you can tell somebody, I'm looking for the 187. Or either if you remember the last name, Boyd, I'm the only Judge Boyd in the entire courthouse. So they'll be able to direct you where you are so you won't be frantic. We actually had one juror who was in this trial, but then was trying to get on a jury in another trial because they were lost. So I know none of you will do that. To my left, Diana, if you'll raise your hand. That is the court reporter. She takes down everything that everyone is saying. If she didn't take it down, that means it did not happen. So it's very important that she's able to take down everything that everybody is saying, because whenever she sends a record up, when it has inaudible or nothing said, unintelligible, that makes her look bad because people are saying, who's this court reporter? And there are so many blanks in her record. I've always told her if that were to happen, I will do an affidavit for her and tell her that people were mumbling, people were talking at once, and people were not speaking up. But she wants to have a great record. So what we're going to do to make her job easy is there will be only one person speaking at one time. We will not talk over each other, and we will talk very loud so that she can hear. And trust me, if she thinks you're talking too loud, she will look at me and give me the signal saying they can tone it down. But so far, we've never had that to happen. So make sure you keep your voices back. And I'm going to try this with the jury. I've tried it with every jury that we've had. And we've been in a jury trial every week. So we've had a lot of jurors. No jury has been able to follow this instruction, but I have faith in you all. Now, mind you, I did say that to every other jury before, but I really feel something about this jury that you all will be able to follow this instruction. So everyone, please raise your cards. And when I tell you to lower your card, I want you to lower your card. Everyone in the box, lower your card. Everyone on this front row only, lower your card, please. If you look around and your card is still up, this is what this means. Whenever you speak or say something, I'm going to need you to stand. And the reason why I need you to stand, if you can, is so that she can hear, because the acoustics in this courtroom, it appears that it's great, but it's really not great. And she cannot hear you if you don't stand. So will everyone be able to do that?
Yes.
Awesome. Do not have my faith misplaced. And if you see somebody who's not standing, just sort of nudge them a little bit. All right. Oh, we have somebody. Is that another juror? Oh, you all can lower your cards now. Hi, are you a juror?
Yes, ma'am.
All right. What is your number?
58.
All right. Thank you. And you, sir, what is your number? 18. Okay. Thank you. All right. Now I'm going to let the parties introduce themselves to you. So for the state.
Good morning, my name is Travis Banks, and I'm an assistant district attorney here for Bexar.
Good morning, and I'm Ruben Herrera. I'm also an assistant district attorney.
And for the defense.
Hi, good morning, Matthew Allen.
Good morning, Ruben Pisania.
Good morning. My name is Raymond Alejandro.
All right. And to my left is someone who's here to learn. So sometimes we'll have people come in and out of the courtroom. Sometimes they're students, sometimes they're legal assistants. And during jury selection, because it's so crowded in the gallery, I always allow them to sit here, but this is usually where witnesses sit. You will see people who will come from out of this door. That's my staff, or some people who have documents for me to sign. It has absolutely nothing to do with this case. So please ignore it and don't start thinking, oh, I wonder what that's about. Trust me, it's nothing to do with this case. When you see people coming through that door, it is because they didn't read the sign on the outside the door that says, please do not come through this door. We're in jury trial. So now you've had a chance to see all of the parties. Raise your card if you recognize any of the parties that were introduced. All right. And even though he's just, I don't want to say just, he's here to learn. Would you state your name, please?
Arthur Meany.
All right. Does anyone know Arthur? Okay. All right. The charge in this case is indecency with a child by contact. I'm going to come back to you and talk to you about that in a little bit, but I wanted to let you know what the charge is. Now, when the state and the defense speak to you, and even when I think we have another juror. Could you check to see? That would either be number 19 or 72. All right, when the state or the defense speak to you, and even when I speak to you, they are going to be talking to you about hypotheticals. Nobody is allowed to talk to you about what they think the facts of this case is until you are actually on the jury and until you actually start hearing evidence. Does everyone understand? So when they're talking to you, thank you. When they're talking to you, they're not talking about the facts of this case. I want to talk to you about an indictment and what that means. How many people, and I'm going to have you practice raising your cards, because when you want to respond to something or you have a question, just raise your card. How many people here have had a traffic ticket before? Don't be shy. Okay, this is another panel that is filled with bad drivers. I've had a traffic ticket before. So when you get a traffic ticket, when I've had one in my entire life, when you get a traffic ticket, in my date and time, they had a notepad and they were teared off. Now I think they probably do something electronically. Well, let's say you get a traffic ticket and they say it's because you ran a red light. When they give you that ticket, by you accepting that ticket, you're not admitting that you ran the red light. That ticket is to let you know, I'm saying, or I'm accusing you of running a red light. This is where you need to be to answer for that. So an indictment is the same way. An indictment is not, thank you so much. An indictment is not an evidence of guilt. It's not an evidence of anything. An indictment is just the piece of paper that lets somebody know what they're charged with and where they need to be. So it is not to be taken as evidence of anything. It is not to be considered by you for anything. Does everyone understand? Is there anyone here who cannot follow that rule? Okay. Now, everybody has certain rights when they're charged with a criminal case. And you're going to see me drink a lot of water because I have allergy medicine I have to take. Everyone has certain rights when they're charged with a criminal case. One is what's called the right to remain silent. Is there anyone here who's not heard the term of right to remain silent? Oh, that's great. Everybody's been watching television shows, hopefully. So the right to remain silent means that if you're charged with a criminal offense, you do not have to testify in your own behalf. Now, some people will say, well, if I'm charged, of course I'd want to testify. I want to give my side of the story. And it's okay if you feel that way about yourself. But the key to that right is you cannot hold it against someone if they decide not to testify. You cannot in your mind say, oh, well, I wonder what they would have done. Well, they should have taken the witness stand. I would have taken the witness stand. You are not allowed to consider it at all. I've been a defense attorney. I've been a prosecutor. And sometimes as a defense attorney, I would tell my client, there's no need for you to testify because maybe the state didn't prove the case. Or maybe I have a client who's very shy. Maybe I have a client who's very young, or maybe my client stuttered. Maybe my client didn't like public speaking. Because if you think about it, it's very difficult sometimes to get up in front of strangers and talk. So is there anyone here who would hold it against Mr. Alejandro if he decided not to testify? All right. Everyone is presumed to be innocent when they're charged with an offense. They're presumed to be innocent unless and until the state proves its case beyond a reasonable doubt. So if you had to vote right now on whether Mr. Raymond Alejandro is guilty or not guilty, what should your vote be? Yes. And the reason why it would be not guilty is because you have not heard anything. Does everyone understand? Yeah. Now, I told you the state has the burden of proof. What that means, and I want you to think of it as weights. All of the weights sit on the state's table. Those weights do not transfer to the defense. So if you're ever thinking in your mind, well, the defense should have done this, or the defense should have put on this, or the defense should have given this evidence, then that means that you have shifted the burden to the defense. Defense does not have to prove anything. Defense attorneys could sit over there. They could do crossword puzzles. They could play video games. They could watch movies. Now, mind you, in my career, I've never seen that happen, but they could. And the reason why they could is because they don't have to prove anything. The burden rests with the state, and the burden never shifts to the defense attorney or to the defense. Does everyone understand? Now, you may ask yourself, what does beyond a reasonable doubt mean? There is no definition. When I was in law school, you had to memorize the definition of proof beyond a reasonable doubt if you were going to practice criminal law. And I always wanted to practice criminal law. This has always been my passion. I knew the definition forward and backwards. I still know the definition. And after my first jury trial, I was so proud of myself because I said the definition without stumbling. I paused at the comma. I stopped for the semicolon. I stopped at the period. I had the inflections just right. And then after that jury trial, they did away with the definition for proof beyond a reasonable doubt. So the defense attorney and the state's attorney will not be able to tell you during voir dire what the definition is because there is not one. So as I continued in my practices, what I would do is I would tell people what it was not, because the last thing I would want a jury to do is to put a different burden on it than what it should be. So the beautiful courthouse, as they call it, the historic courthouse next door with the green rooftop, they handle civil cases. So the burden of proof in civil cases, one of them is preponderance of the evidence. That means more likely than not, something happened. That is not the burden here. Proof beyond a reasonable doubt is a higher burden than that. So if you're ever deliberating and you're thinking, well, more likely than not, this happened, that means that you're not at the burden you should be. You are at the burden for a civil case. The other burden they have is a burden called clear and convincing evidence. Clear and convincing evidence is the evidence that's used to terminate or to take away someone's parental right to their child. So that means that somebody's saying, maybe you're a danger to your child and we can't trust you to parent this child. That's the burden for that. And again, that's on the civil side also. Proof beyond a reasonable doubt is a higher burden than that. Proof beyond a reasonable doubt is the highest burden we have. Does everyone understand? So if you find yourself deliberating or thinking about things, and that's what's going through your mind, those burdens that I've told you, then you are not at proof beyond a reasonable doubt. Does everyone understand? Now, there are two phases to a jury trial. The first phase, people usually call it innocence phase, but it's really not the innocence phase. Phase one is whether somebody's guilty or not guilty, whether the state proved their case or did not prove their case. That's phase one. If phase one, you find somebody not guilty, there is no phase two, because phase two is what is called the punishment phase. In criminal trials, anyone who's charged and decides to go to a jury trial, they have to make an election or a selection saying that if I were found guilty, either they will say, I want the jury to handle punishment or I want the court to handle punishment. That is the law. They must make an election. Now, when they make an election or selection, they're not saying I'm guilty. They're just saying, hey, I'm going to follow the law. The law says I have to make a decision whether the jury will decide punishment or whether the court will decide punishment. In this case, Mr. Alejandro has decided that if he were to be found guilty, he would ask that the jurors decide punishment. Is there anyone here who's going to hold it against Mr. Alejandro that he's decided that if he were found guilty, he would like the jury to set punishment? Okay. Now, is there anyone here for religious reasons cannot sit in punishment? All right, in this case, the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Now, people always wonder about the $10,000 fine. Nobody knows where that goes. Everybody knows where it's supposed to go. And I teach at UTSA, so I've even had my students, as a part of their assignments, do research on where fines go. And we all know where it's supposed to go, but honestly, it goes in a black hole and nobody knows where it is. So I'm going to focus with you right now on the range of punishment, the 2 to 20 years in prison. Now, if you're going to be on this jury, you have to be able to consider the entire range of punishment if somebody were found guilty. Does everyone understand? Now, people will ask you, can you consider the full range of punishment? And usually the response we get back from jurors is, well, I don't know. I need to know facts. The problem is you will not know any of the facts of this case unless you're on the jury. So you have to think in your mind what it means to you and whether or not you can consider the full range of punishment. Sometimes you have cases where maybe someone is 19 years old and maybe somebody's 13, or maybe somebody's 90 and somebody's 12. There are whole different fact scenarios that falls under the offense of indecency with the child by contact. So when you're asked to, will you consider the full range of punishment anywhere from 2 to 20 years if you're on the jury, nobody's asking you if you will give 2 years, if you will give 3 years or 4 or all the way up to 20. What is being asked of you is, one, does everyone here recognize that the range of punishment for this offense is 2 to 20 years? Okay. Now, then the next question is, would you be able to consider that? And what do I mean by considering that? If you were to find somebody guilty of this type of offense, would you be able to apply whatever facts you have and make a decision on the range of punishment? Is there anyone who cannot do this? Okay. Could I have parties approach just briefly? All right, so the next thing I want to talk to you all about is languages. I love languages. I thought I would be retired at 21. Here I am, 22, and I'm still not retired. Okay, the laughter should not have been that much. You all should have said, oh my gosh, she must be a genius. So I'm originally from Louisiana. So when I was in junior high and elementary school, now I think they call it middle school, I decided to take the second language where I thought I would be spending my retirement years. So that was French. I had no idea I was going to be in Texas. My friend Tanya said, Stephanie, let's take Spanish together. And I told her, I'm going to be in Paris. I'm not taking Spanish. Ah, how I regret that. So when I was in, well, not really regret because I still know another language, but when I was in law school and in graduate school, and even in undergraduate, I was surrounded by people who spoke so many different languages, and they were trying to teach me their languages. So I can say hurry up in Navajo, Farsi, Spanish, French, basically every language you can think of, Arabic. So is there anyone here, and I want you to raise your card if English is not your first language? Do not be shy. Nothing will happen. All right. 10. When I call your number, lower your card. 10, 23, 26, 28, 31, 47, 49, 61, 67, 70, and 71. Is there anyone else? All right. Remember my rule about standing, everyone. All right. Number 10. What is your first language?
Spanish.
All right. Have you been able to understand everything that's been said? All right. How do you say hurry up in Spanish?
Apúrate.
That is correct. All right. Thank you. Number 23. What is your first language? Right. And have you been able to understand everything? All right. And was she correct in saying, how do you say hurry up in Spanish? All right. You get an A2. Number 26. What is your first language? All right. Have you been able to understand everything? Now, I've had Spanish speakers in here before, and they've given me 2 ways to say hurry up. What's the second way? Thank you. Number 28. Yes. What is your first language? All right. Have you been able to understand everything? And are they correct in translating for rapid? Oh, she's giving you all to look like maybe you're not saying it right.
So we say us.
Oh, well, thank you very much. I've learned a new one. Thank you. 31. Yes. What is your first language?
Spanish.
Have you been able to understand everything?
Yes.
And were the ladies correct in giving me how to say that? All right. Thank you. 47. I think I'm going to get a new language. What's your language? Have you been able to understand everything? All right, we can go. I know you won't be able to write this. How do you say hurry up in Vietnamese? Oh, I can say that. All right, thank you. 49. Yes, what's your first language?
Spanish.
Have you been able to understand everything that everyone's been saying? All right, and were they correct in saying hurry up in Spanish? All right, thank you. 61. Yes, what's your first language?
Spanish.
Have you been able to understand everything?
Yes, ma'am.
And were they correct in how you say hurry up?
Yes, ma'am. The only one I had never heard is the one that she said, and I didn't understand it, but yes, they were correct.
All right, thank you. 67. Your first language? Have you been able to understand everything? All right, and were they correct in how they said, hurry up? All right, thank you. I'm just waiting for somebody to say, nope, they were not. Number 70. What's your first language? All right, I'm gonna need you to speak up because she needs to hear. All right, have you been able to understand everything? All right, thank you. 71. What's your first language?
Spanish.
Have you been able to understand everything?
Yes, ma'am.
And were they correct in what they told me?
Yeah, they were correct.
All right, thank you. She said that with confidence, so I appreciate that. All right, so the next thing I want to talk to you all about is travel arrangements. Is there anyone here who has any type of time constraints or travel arrangements? By travel arrangements, I mean that you are leaving, you have non-refundable tickets, you cannot put it in my name. Is there anyone here who has that? Raise your card. I'm gonna let that marinate because usually people will not raise their card on the first time. So now's the time to raise your card if that's the case. If you do not raise your card, when I call out these numbers, I will not come back around to you. All right. When I call your number, please lower it. Number 3, 10, 11, 12, 13, 15, 23, 20, 30, 33, 35, 49, 51, 52, 54, 67, 69, 71, and 74. All right, number 3, what is your time constraint or your issue?
I have to pick up my child here.
All right, and what time do you have to pick up your child?
4.
Number 10.
I have a trip to California next week,
All right, when do you leave?
Friday,
Oh, what are you going to California for?
San Francisco.
And why are you going? Just to see?
No, we had, my husband surprised me with a trip for my birthday.
Oh, wow. Is he letting you go by yourself or is he?
Oh, no.
He's, yeah.
Definitely not.
You should be like, I lost your ticket. I'm sorry. All right, thank you. And that's Friday next week, correct?
21st.
Number 11.
The 23rd, we have a family vacation to Florida,
Oh, what part of Florida?
Pensacola.
All right, who's all going?
The whole family, my wife, kids, my mother-in-law, my sister-in-law.
All right. Do you want to use this as an excuse not to be with your in-laws? And then you'll blame it on me. Judge Boyd wouldn't let me go. All right, thank you.
Probably.
Okay. Number 12. All right, where are you headed? Oh, what are you doing in Idaho? Oh, wow. I'm gonna have to put that on my bucket list. Is it going to be hot there? Oh my gosh. Does Hell's Canyon sound like it's going to be hot? I mean, just in the name?
It's unusual that far north these days.
Well, take plenty of water and don't get lost and have a GPS tracker. Okay. Number 13.
So I had to them. Then I have MRI appointment this Friday.
All right, so that's this Friday. Well, I think everything is going to go great with the MRI. Number 15. Oh, so you just want to let us know so we can be jealous. Oh, that's okay. What are you going to be doing in Colorado? Oh, wow. Well, enjoy. Safe travels. Yeah. Oh, if we're here till the end of August, there's a problem. But hey, you're number 16. Where are you going in August?
I'm going to go later.
All of my great places. But you know, I appreciate the fact that you didn't want to put that out there for us mere mortals, but Rome is one of my favorite places. Do you know, when you go to Rome, the people are still upset with what happened to Caesar? I mean, they are still highly upset by that. So you may run into some people who will talk to you about that. Number 20.
But my trips are also in August, but I'm going to Seattle in August and Yellowstone in.
Oh, awesome. When you go to Yellowstone, don't do what some of those people say, you know, where they want to put their hand in the water and see if it's really hot. It is hot. I've seen some people do that. Don't do that. All right. Number 23. All right. What are you doing in Cancun?
Celebrate my birthday this coming, and then in September, just.
All right. What are you doing here? I think people should celebrate their birthday the entire month. So happy birth month. All right. And then other people who are no longer afraid to raise their cards. Number 25.
So I have my son next week.
Mhm.
All week, and I don't have any arrangements for him.
Okay.
And I also have a trip at the very end of this month, early next month, that's non-refundable.
Oh, where are you going?
I'm going to Rockport. I'm taking him fishing.
Oh, wow. Awesome. How old is your son?
He's 11.
You know what? He's going to remember that always. All right. All right. Thank you. 26.
I have a ticket to go to the 21st.
What are you going to be doing in Mexico?
Yeah.
Oh, wow. Thank you. 30.
I have a couple of doctor's appointments that I've had to reschedule because of jury duty that I cannot get out of from surgery.
Okay.
Those are tomorrow, and then I am leaving the week after.
All right. And you're just throwing that Florida in there for us, Audubon.
I still feel too bad.
Yeah. So are you going to Florida with number 11? Are y'all going to be driving up together or something?
Maybe.
All right. Thank you. Number, okay, 31. Yes.
Because everybody was, when you said long-term, I thought you meant like next week. School starts on the 31st as a teacher.
Mhm.
So I don't know if that would excuse me, but we also have like meet the students and all that on the 26th.
Okay. All right. Thank you so much. 33.
So like 13, I'm in September, so I just manage expectations.
Oh, September.
September 14th,
Okay. What are you doing in September 14th?
I'm going to England and Wales.
Oh, look at you. You and the person who's going to Italy, just trying to make us all jealous. All right. Well, enjoy. Number 34.
I'm going to be participating in a prison ministry on Saturday.
All right. Which prison are you going to?
Forest unit.
All right. Thank you so much. And thank you for your work. 28. Are you raising your card or not?
Yes, sorry.
Yes.
I thought it was like for this week only, but I'll be out of town next week. We're going.
Who are all these people going to Florida? What are you doing in Florida? And who is we?
My family, my sister.
All right. You don't want to break from them?
No.
Okay.
We're close.
All right. Thank you for letting me know. Number 5. You're making me backtrack.
I'm leaving on the 22nd.
Mhm. And are you going to Florida?
Nothing as fun as that.
Yeah. Where are you headed?
My stepson just got a professor job at Western Illinois University, and we're helping them move.
Oh, awesome. That'll be fun. All right. Thank you. 35. All right. 23rd. All right. Thank you. Number 9. Yes.
I was also thinking I'll be in Brunswick, Georgia on the 31st.
All right. Just so everyone knows, I don't think this is going to go into the month of August. I don't think this is going to go to the end of July, but we'll see where we are. Number 49.
But we got going to Cancun,
family next week.
Are you going with number 23?
I don't think my wife will appreciate that. But if you can take care of my kids, I'll be great though.
All right. Thank you. 51,
Go ahead, Nashville.
Nashville on the 27th.
Yeah.
52,
I have a funeral to go to on Sunday in Louisiana, 25.
oh, which part of Louisiana?
And
Okay, I've heard of it. I'm sorry to hear that. Thank you. 54,
Florida, Thursday, next week.
Thursday. What are you doing in Florida? Oh, okay, thank you. 67,
Have a church ministry that I had committed 4 months ago, and it starts tomorrow, Thursday.
all right, thank you. 64,
My mother has her 3rd round of infusions the weekend of 31st, and it's a 5-day.
okay. 69,
scheduled surgery on this Friday, the 14th. And
I'm sorry, your voice dipped down, I couldn't hear.
so, scheduled surgery on the 14th, Friday, and also on Monday.
Okay. All right, 71,
Yeah, so I had 3 things, but now that it's not going to August, I have 2 things. So one, I just started a job a month ago in the Valley. So I'm in the Valley. I just came back for this jury. And then 2, my sister's wedding in Mexico is gonna be from the 20. I'm gonna be leaving from the 21st to the 24th.
21st to 24th for the wedding.
Yes.
All right, and what is your role in the wedding?
Helping with like logistics and things like that.
Okay. I asked this question. One time I was doing jury selection and a judge asked somebody, what's your role in the wedding? She's like, I'm mother of the bride. The judge was like, they won't need you, but okay. All right, I have that down. Thank you so much. Number 74.
But you said August was pretty much out. My trip is 3 August to Memphis.
Memphis. All right, what are you doing in Memphis, Tennessee?
Riding motorcycle with guys.
All right. All right, that's great. I just had a friend of mine drove from San Antonio on a motorcycle all the way to Canada. His plan was to go to Alaska, but at Canada, he was like, I'm stopping. All right, thank you so much. All right, is there anyone else? 42?
Starting a new job.
All right, and what are you doing at your new job? Okay. All right, thank you. All right, so before I turn it over to the state, the other question, you all have now had a chance to see each other speak and get a chance to look at each other. And I know you all had a chance to see each other downstairs and then in the hallway yesterday. So is there anyone here that knows anyone on this panel other than just standing out in the hallway yesterday or meeting downstairs? If you do, raise your card. That's very odd. Usually there's a teacher on and there's a student. So none of you know each other. We're just all complete strangers. Okay. All right. So I'm going to tell you all 2 stories. Both of them are true. My family grew up in a small town called Grand Cane, Louisiana. And the reason why I tell jurors this story is because when you think about jury duty, sometimes people are like, oh, I have jury duty. I really don't want to be here for jury duty. Oh, no. Well, it's an inconvenience when you really think about it. It's an inconvenience because you have to find parking. And if you're not downtown on a regular basis, you get lost. I don't know why people put a bunch of one-ways downtown, but when you're driving and you see that one way and you're just think you're running late and you're like, the building is right there. If I could just make this turn, but instead I have to make this circle. Parking costs. And you're like, I'm coming down here to do jury duty. I shouldn't have to pay for parking. And then it's hot here. The chairs are hard. I always tell people that's an inconvenience. And the reason why I tell people it's an inconvenience and not a sacrifice, because of my uncle. So my uncle grew up in Grand Cane, Louisiana. The population now is extremely small, but back then it was in its heyday, it was probably 2,500 people. So as you can imagine, everybody knew everybody. My uncle was my grandmother's firstborn. Both of them have since passed, but super intelligent. And the teachers would constantly skip him to the next grade because he was so intelligent. So he ends up graduating from high school. And of course, his sister and his brother were like curses. He's super intelligent. And the teachers would always tell them, we know your brother, you better bring it here like your brother brought it and be super intelligent. So after my uncle graduates, Vietnam War breaks out and people are being drafted. And in Grand Cane, Louisiana, a lot of people are being drafted. He tells my grandmother, look, they're drafting all of the boys here. I can't be what I want to be or do what I want to be because things are limited for me here. So I'm going to just go ahead and sign up. So my grandmother had to sign for him because he was underage. Now, to me, that's a sacrifice because when you think about it, it's not like today where you can send somebody an email, where you can get on the phone and call them and say, how you doing? My mom still remembers their phone number. And that was back in the day where you would call the operator to dial the next person for you. And my mom said their phone number was 4 digits. So it wasn't the fact that my grandmother would sign and send him off and, hey, let me shoot you an email. Hey, let me send you a text message. Hey, let me call you on your cell phone to see how you're doing. So that was a struggle for her, but she signed for him to go off and fight in the war. And when you think about it, during that time, nobody really knew where Vietnam was. And she's sending her firstborn off. Doesn't know if he's going to come back or not, because if you know your history, people were being killed. And so she's just sitting there writing snail mail. You don't know if they got the letter or not. So for me, that's what a sacrifice is. Your government only asks 2 things for you: pay taxes and do jury duty. And they're not even asking you to do jury duty every week. It's years before you get your next card. So in order for us to have jury trials, the number one thing we need are jurors. And both the state and the defense, they want jurors who will sit in the box, listen to a case, and make a decision based upon that. This case is indecency with a child by contact. And I know some people like, oh, I wish I would have just got a car accident case, or I wish I would have got this. Everybody always have strong feelings about different cases, maybe because something has happened in their past life. People always use the hypothetical of, oh, my car just got broken into, so don't pick me to sit on a trial where a car was broken into, because I have feelings about that. And it's okay that you have feelings about that, but in any type of criminal case, and in this case, the only question is whether or not you will be able to sit on this trial and base your decision on what you hear, not what happened to you. If something has happened to you in your past, it means being able to sit in a jury, listen to people testify, and base your decision on whether somebody's guilty or not guilty based upon what you hear. Does everyone understand? Is there anyone here who can't do that? All right. Number 15, 50, and 63. And number 3 and 25. All right, thank you.
Your Honor.
Oh, 59, thank you. All right, now the next thing I want to talk to you is another true story in my life. When people graduate from law school and decide what they want to do, some people say, oh, I just want to do civil, or some people, I want to do patent law. I always wanted to do criminal law. So one of my best friends, she always wanted to do civil law. And we would never get a chance to see each other because I was always in court or always in trial, and she was always at a civil firm. So one day she gets called up for jury duty. And she calls me and she says, Stephanie, I got called up for jury duty. Let's do lunch. I'm like, yay. So we do lunch. And it's like we have never stopped talking. It's almost like we've been talking every single day. We're back in law school together. We're giggling, we're laughing. And I asked her, how is jury duty? And she's like, it's going fantastic. Well, now that I'm a judge, I'm like, how can it be fantastic? You're not in jury trial with me. But so she tells me I am not going to be selected for the jury. And I'm like, what do you mean you're not going to be selected? How do you know? And she says, because it's just like when I was in law school. I'm sitting at the back, I'm keeping my head down, not asking any questions. So I start laughing and she says, what's so funny? I said, we're going to have lunch every week. So the way to get selected on a jury, other than saying, please select me on this jury, is to be quiet. And I always tell that story to jurors because the defense and the state has this small amount of window to speak with you. Both the state and the defense are going to have 45 minutes to speak to you. And it's during that time they have to make decisions. So they want you to talk as much as possible so they can get to know you in that small window. Okay. Now, before I turn it over to the state, is there anyone who needs a break? Raise your card now. All right. So you can lower your card. Thank you. So I'm going to give you all a break. We're going to come back at 10:20. So what that means, everyone look to your left, look to your right. Like in paper chase, you're responsible for that person. If you are taking a restroom break, find a stairway. You can go on any floor. If you are next to a stairway, the restrooms are going to be on either side of that stairway. So if you want to leave your items, your personal items here while you go do that, you're more than welcome to do that. Your items will be safe here, but everyone must leave together. So make sure you're lined up outside at 10:20. Do not come in the courtroom, just line up outside, all right? All right, everyone, please rise for the jurors. Oh, yes, you're welcome to leave. Thank you. prison. I'm like, oh no, I asked for things from the prison. I used to do it. I would call the prison all the time when I was a defense attorney. Can I get, and so I learned their process.
Yeah, that's the thing. There's areas
Matt
that
Allen and
as a prosecutor.
Yeah. All right, we're going to go on the record in 2021 CR 5164 State of Texas versus Jonathan Boyd. Can I have parties announced for the record for the state? Depends. And are you Jonathan Boyd? All right, so we were here because the defense, you were asking for a continuance and the state had no objection to your continuance. Is that correct? All right, the court will grant the continuance, Mr. Boyd. I think that everyone should have everything and see everything as it exists in reality, for want of a better term. So I am going to extend your plea deadline date. We're going to come back on Thursday. Are you employed?
tomorrow.
Yes.
Yes, I am.
All right, so we can do it. Well, we can do it by Zoom. Are you able to do it by Zoom? All right, what is your break at work?
Well, I'm self-employed, but I just have,
All right, what time?
9.
All right, so we'll put you at 10 a.m. So your attorney will get the Zoom link, so you Zoom in at 10 a.m. So what we're going to do tomorrow is, with regards to the DNA information, without objection from either party, you all were in agreement with me calling the DNA person to get the packet together. Is that correct, state defense? All right, so they were giving you all a month's date, but when I talked to them, they said they think they'll be able to have that packet prepared by next week. So I've given them hi, come on in. I've given them my cell number without objection from either party and my email address without objection from either party. So what will happen is, if they send me anything, that will be forwarded to both your counsel and to the state. If for some reason they email me the packet, which I don't see them doing, but if they do, I don't read any evidence or proposed evidence that's sent to me. I will send it out to your attorney and the state. And then, of course, afterwards, if somebody wants me to read something, then I will do it at that time. Is there any objections to that process, state defense? All right, so we're going to be back tomorrow at Thursday. I've granted your motion for continuance. I'm going to extend the plea deadline date, but when we come in on Thursday, hopefully I will have the exact date next week when they will have that packet. And then on Thursday, you'll be able to get your new jury trial date and plea deadline date. All right, is there anything else? All right, so I'm going to see you tomorrow on Thursday. Your attorney is going to inform you, and I will inform you when you're on Zoom tomorrow, because you have to work and I want you to miss work. I will inform you on Zoom tomorrow when your next jury trial date is and your next plea deadline date is, okay? And the plea deadline date and jury trial date will be the same. But I'm asking that if there's going to be a plea entered, don't wait to do it on the day of the jury trial, because we'll be thinking a trial will be going, state will have their witnesses or not. So everyone make sure that that's done before we get to the jury trial date. All right, is there anything else? All right, we'll see you on Thursday. All right, thank you.
Ready for the jury?
Just one moment.
All right,
Does anybody want to chat more?
5 minutes, I guess.
Same here.
Yeah.
Yes.
You know, my mom always says when people fall, they always think it's their fault. You know, oh, I should have been in a hurry. I shouldn't have done this. And I'm like, no, it's not their fault. Because my mom has had falls before and it wasn't her fault. Mhm. Or if you ever have a question about the process or anything, you can feel free to ask me anything. You're welcome. Yeah. All right, everyone, please be seated. All right, so number 17.
Sorry, Your Honor, I just found out over the break that I have to go downtown Friday. Friday, 21st. I just wanted to let you know.
Oh, thank you so much. So Friday. And where are you going to be going?
I'll be-
Oh, what are you doing in Houston? Okay. And dealing with Houston traffic. Right. So, ladies and gentlemen, juror number 12 is not going to continue to join us because she did have a fall, but I want everyone to know that she is fine. Of course, we always like to take extra precautions to make sure nothing has happened. So she may have just sprained her ankle. So it's a good thing we had an EMT here who jumped into action. So I don't want you all to worry about that because I know you saw her being carted off, but that's the reason why. It's just extra precaution. She didn't even want to take the cart, but we're like, no, we're going to make sure everything's okay. So she's going to be fine, but she has been excused from the jury because she needs to take care of that. All right. All right. With that being said, remember my instructions. If you are in the back and not in this box or on the front row, if you can, stand when you are answering a question. And everyone, make sure you keep your voice up so everyone can hear, especially the court reporter, okay? All right, State, I'm going to turn it over to you.
Thank you, Your Honor.
And if anybody ever needs a break, just raise your hand or do the break sign and we'll make sure we take a break. All right, State.
Good morning. We're going to talk today about a few things. Like I said before, I'm Travis Banks. I'm an assistant district attorney here in Bexar County. And we're here today to do a voir dire. So let's just kind of talk about the goals of a voir dire. So we're going to want to talk about the law. In those discussions, we want to learn about you guys, our jurors. And in the end, we're going to narrow it down to 12 fair and impartial jurors who are right for this case. You see this case is underlined because you might be right for maybe another case, but there may be a juror who's maybe not right for this case. And so we know you have strong opinions. I got this picture up here. There's a lot of classic movies about jury duty out there. There's like 12 Angry Men, but there's also a little movie called Jury Duty with Pauly Shore. It's a great movie. If you have time, watch it. You'll have a ton of laughs. But in that movie, a lot of the jurors wanted to vote one way, and old Pauly wanted to vote the other way. There were a lot of discussions in the back, and we know you guys are going to have strong opinions. You're going to have discussions. Hopefully they won't turn out like this. But we want to kind of understand your opinions and make sure that nobody gets back there with some opinions that just make you biased and unable to render a fair judgment in this case. So what's an impartial juror? A juror is someone who's able to render judgment about the facts without your personal biases clouding your judgment and preventing you from drawing rational conclusions about the facts. And your biases aren't always going to be obvious, and maybe you don't even realize you have some of the biases that you have. And so that's why we're going to be kind of having the discussions. And your biases can be based on your experiences, or your habits and things that you like to do in your life, or someone, maybe you have a relative who does a certain thing, or their experiences. Your biases can come from pretty much anywhere. So here's our ground rules. We can't talk about the facts of the case. There's not going to be any right or wrong answers, and I'm saying that to say that we're not going to try to change your mind here today. Like, I just want to know what you think. I'm not trying to, we're not going to grade your opinions at the end of this. So just be honest and please participate. Like the judge said, if you don't participate, we're not going to know your opinions. And then, you're just going to wind up on the jury.
Excuse me, counsel.
Yes.
If you could just give me one moment, please. Everyone, just one moment. Ladies and gentlemen, I'm sorry about that. Sometimes I have other judges that are calling me for matters I need to take care of and sign different documents, like I told you before, but it has absolutely nothing to do with this case. All right, State.
Thank you. So if we don't really hear from you what your opinions are, you may wind up on the jury and we're not even going to know what kind of juror we wound up with. So please participate and be honest. So let's start with bias from personal habits. Who recognizes this man on the screen? Number 25, who's on the screen?
Willie Nelson.
And Willie Nelson, what do we know about Willie Nelson?
He's a fantastic songwriter
Mhm.
and musician.
Yep.
And also likes to partake in
Coffee, right? He's got coffee right there. Yeah.
coffee.
No, so he likes to smoke pot, right? That's Willie Nelson. It's well known. Here's even a picture of him doing it. He's not shy about it. And let's say we're not doing an indecency with a child by contact case today. Let's say we're doing a trial hypothetically about marijuana. It's 5 to 50 pounds of marijuana, a third-degree felony. And Willie Nelson's sitting out there in the crowd, and I'm doing my voir dire. Do you think I'm going to want Willie Nelson to wind up on that jury?
No.
Right? So Willie Nelson would probably be a biased juror for that type of case. Maybe not for this case. I'm sure if Willie Nelson were sitting in the panel today, I'd be happy to have him on my jury, because the fact that he thinks marijuana is fine and should be legal has nothing to do with what he thinks about an indecency with child by contact case. So that's an example of someone who's maybe not right for one trial, but could be right for some other trial. For another jury. So what brings us here today? It's indecency with a child by contact. It's a very serious charge. I would imagine when most of you guys heard that that's why you were here today, as the judge said, you probably wished, anything but this. And, I'll make a confession, me too. I wish we could have tried a murder today, but this is the type of case that we're going to try. So there's two phases of the trial. There's the guilt/innocence phase and the punishment phase. And note the Great Wall of China that I put there on the screen. That's to indicate to you that there's a great wall between these two phases of trial. You consider the guilt-innocence stuff in the guilt-innocence phase. You consider different things in the punishment phase. The point is not to consider the punishment stuff while you're considering the guilt-innocence stuff. What are you going to consider in the guilt/innocence phase? Well, the elements of the offense for indecency with the child by contact. So we're going to talk about on or about some date anterior to the indictment, because there's no statute of limitations on these things. An exact date is not needed, but you could get an exact date, but you will be considering a date anterior to the indictment. The defendant, in this case, the defendant's Mr. Alejandro, intentionally or knowingly engaged in sexual conduct, and this is where it maybe getting a little more tricky. Touching of the genitals, anus, or female breasts is what's considered to be sexual contact. So, just knowing that's the kind of thing that may be discussed throughout this trial, the touching of genitals, anus, or a female breast. And it can be over or under the clothes, and the person being touched would need to be a child younger than 17 years of age. And then the last element is that the touching was done with the intent to arouse or gratify the sexual desire of anyone. Could be the defendant, could be the complainant, could be some third party. That's a pretty broad term. So the second phase of the trial is the punishment phase. That's when you can consider things more broadly, not just the elements of the offense. You can consider other things like, does he need help? Do you think he doesn't deserve jail time? Do you feel sorry for him? Do you feel like there's substance abuse problems that need to be treated? Are there mental health issues? Those are the things to consider in the punishment phase. You don't consider those types of things in the guilt-innocence phase. So now let's talk about what it means to do something intentionally or knowingly, because the contact that we're talking about has to have been done intentionally or knowingly. So, I guess we can start off talking about what that isn't. So if you intentionally or knowingly do something, we're not talking about negligent. We're not saying I made this contact on accident or negligently. I didn't see you. I was just raising my arm. So intentionally, that's your conscious objective or your conscious desire. Like I walk up to someone, I'm greeting them, and I reach out and we shake hands. That's an intentional action. We're shaking. That's what we want to do. Knowingly is a little different. It's kind of similar to being intentional about something, but it's almost like hitting a domino. Like you got dominoes lined up. You hit one domino, and you know that last domino is going to fall, and you didn't knock that last domino over, but you started that process, and you knowingly got that started. And we can get into more detail about that. I think it's kind of easier to explain. You don't have to read anybody's mind. I think you don't have to be able to look inside their head and see what's going on. You can tell what someone intends to do or what they know to do just by their actions, their words, how those actions would be interpreted by another person. So let's talk about what needs to be proven again. We're talking about the elements of the offense. That's what needs to be proven. And what doesn't need to be proven is the why. What's not in the indictment, what is not required to be proven is why someone does whatever it is that they do. We just have to prove that that's the thing that they did. We don't have to prove basically the defendant's motive. So let's talk about the burden of proof. The burden of proof is on the state. And the state must prove all the elements beyond a reasonable doubt. Who here knows what that means? 17. Looks like you were thinking about it. Yes. What in your mind? What are you thinking when you hear the words beyond a reasonable doubt?
That you guys have to prove it so that there is nothing that I could think that would reasonably make him.
Right, reasonably. I think that's the key word is reasonably. And so we're saying not beyond all doubt, right? That's not, we're not saying that. We're not saying 100% beyond a shadow of a doubt. Right, because you can cast doubt on pretty much anything if you are allowed to cast unreasonable doubt upon it. Let's say you've got kids and the cookies went missing from the cookie jar, and you confront your child about it, and they say that it was aliens that took the cookies, but there was nobody else other than the child who could have taken them. Would it be reasonable for you to doubt that the child took them because they suggested, well, maybe it was aliens? Probably not, right? Maybe aliens exist, but they probably didn't. They're not coming down and taking cookies out of the kitchen, for sure. So that's the kind of thing. So let me maybe illustrate it. Just because something's possible, 1 in a million, 1 in a billion, it doesn't mean it's reasonable. One point we also always like to make is you're not required to leave your common sense at the door. In fact, you are encouraged to use your common sense when trying to rationally understand the facts that you're presented with. And so I'm going to ask, what kind of flag is that right there on the other side of Judge Boyd with the eagle on the top? Who wants to hazard a guess? I don't see your number, you're 3.
United States flag.
That's the United States flag. I am going to challenge you on that because you can only see like a little sliver of it, right? It's hanging down. I don't know, maybe that's like 15% of the flag that we're looking at there. So like, would it be possible that someone as an art project made a flag that looks like the American flag when it's hanging down, but then when you go pull it, it's like all green there? Is that possible?
Possible.
Okay, so, but you think it's the American flag. Do you think it's the American flag beyond a reasonable doubt? Do you think it's reasonable that someone came in here and put in a fake American flag as I just described?
First, I would hope they wouldn't.
Yeah. So why are you so sure that it's the American flag?
Because I can see the opposite side of the flag too.
And where are we?
In the courthouse.
So it would be unreasonable that someone would have there'd be a different flag, right? It's the flag, right? So that's the idea. So there could be an unreasonable explanation for something, but what we're talking about is proof beyond a reasonable doubt. And a quick way, to kind of suss out any doubts you might have, or if there's doubts, you ask yourself, do I have a doubt? Is it reasonable? And does it go to one of the elements of the offense? Because if it doesn't go to one of the elements of the offense, right, then it's not really relevant to your considerations in the guilt innocence phase. If it's not reasonable, right, then it's not a reasonable doubt. So we don't need to be talking about it. And if you don't have a doubt, then we're already beyond considering whether it's a reasonable doubt. So if you believe beyond a reasonable doubt that honor about some date anterior to the indictment, that the defendant, Raymond Alejandro, intentionally or knowingly engaged in sexual conduct, that's touching of genitals, anus, or female breasts, could be under the clothes of a child under 17 with the intent to arouse or gratify the sexual desire of anyone, then the state has met its burden. You vote guilty. So let's talk about child consideration. So this isn't just, touching any person, but there's a requirement that the victim in this case is a child under the age of 17. So let's, maybe for a moment kind of put ourselves in the shoes of this child. And this is the part where I will want to get honest opinions from everyone. How do you guys think a child would react to sexual abuse? And number 60.
Probably be afraid to tell anybody or confused how that happened.
Okay. 37.
Okay, so thank you.
38. Right. 2.
Maybe feeling guilty that it
Guilt.
was their fault.
Feelings of guilt. 71.
Yes, I might not even know that happened.
Right. Maybe they've never experienced anything like that or been taught. Maybe they don't know what it is. 37 again. Sorry.
Is it to be assumed that it needs to around by adult in this question?
Well, so the sexual arousal element only goes to the intent of the person doing the touching. So they are doing the touching with the intent to arouse themselves or gratify themselves or someone else. And number 6.
So I believe this is a very broad question
Yeah.
since you're not the age.
Okay, good point. 3.
Used and scared.
Okay. And 49.
Confused, depending on the age, a child was this older teenager or younger kid,
Mhm.
so there's confusion here.
And 50, did you have something to add?
I would say intimidated.
Right. And 24.
It may not, depending on the age, they may not even know that.
Correct. That is correct. So let's move on to so when a child is ready to tell, like, what are some different ways they would tell? And maybe I've already revealed the answer, but if anyone wants to chime in on how a child might tell somebody, number 6.
They start feeling very uncomfortable.
Okay. Feeling uncomfortable might cause someone to want to tell. Number 3.
Angry.
So they may be angry when they
Don't know how to
tell.
express their feelings, so they're just angry at everything, angry at the world.
Okay. Number 11.
They are angry. Acting out, doing it to others. That's them.
More of the same kind of conduct. 21.
Behavioral changes around.
Okay. 33.
Depending on the age of this child, there may be verbal or non-verbal behaviors that are usually not. But the child. Normally.
Okay. 31.
They may come across as angry and their self-esteem completely gone. In the way they behave and the way they are.
Right. 35.
Okay.
Mhm.
No, I think it's one. I'm sorry, ma'am. I'm sorry, I can't hear you. An outcry for a young child, depending on the age or the age.
And 35. You said you worked in a school. You had any outcries occurred in your school that you know of? Okay.
Elementary. Yeah, there's.
Does it happen to both boys and girls? Okay. Thank you. 36.
Behavior, most kids will kind of shut down, sometimes they'll act out aggressively. They'll literally talk to somebody, but it'll be stuff that we get there. And once they calm down.
And 56 in the.
We might write it down in the journal and show it.
Yeah, they could write it down. Yeah. Good point. 60.
Again, it is kind of a broad question because we don't know the age, but I'm also a teacher, and so there's certainly, you know, like a lot of times it comes out in pieces. So like they might tell a teacher something, and then once they're actually in a situation talking to like an investigator, they might be able to give more details. Or so I don't want to say the story can change, but the story can expand, if that kind of makes sense. Like they might tell you, my dad is doing something to me, my dad hurt me. And then when they actually start talking to someone else, like a counselor or investigator, it might come out that it's not just physical abuse, it might also be emotional or sexual.
So people don't always,
It doesn't always
tell
come
the
out
whole
as just
thing.
one giant,
yeah,
this is everything that ever happened
Yeah.
in my life.
good point. And 59.
I feel like it's a broad question. I worked with peds before, so it's kind of like we don't know the age of the kid. We also don't know if that kid has a disability or not. So are they able to speak for themselves, or do they think it's some sort of game the way that it was brought onto them? And wondering why these other people don't do it the same way, how it was projected.
Good point. And anyone else back there, 67 and then 75 after,
Restless, can also sleep, anxious.
right? And 75,
I would see that sometimes their behaviors might change, especially if they're younger. So they might exhibit sexual behaviors towards other kids, like if they're at daycare.
and then anyone else, look 28. Go ahead, yeah.
I was gonna say I'm a teacher as well, so. That's thinking of younger age. And as well as.
Okay, and 25,
Yeah, I think, you know, your question. Once ready, right? I think that could also, they could never be ready. It could
Yeah.
never change.
Yeah.
You know.
that's a good point. Does everybody, come forward? Does every case get reported, I guess, in your? Yeah. And 39,
Say like bitterness. Parents.
mhm, could be. And so let's move on. So do most kids tell right away? Anyone have any two?
I was just gonna say earlier that sometimes they might not say anything at all, and then they go on through adulthood and something comes up and brings it up.
Mhm. 6,
Depends on the age.
mhm, at 37. Mhm. And 18, did you? have something to say? Yeah. And let's say, and I brought it up briefly a moment ago, but let's say that, there's different victims. Let's say if the victim is a boy, do you think there's reasons why a boy as opposed to a girl might be hesitant to coming forward? 71, yeah.
There's a lot of stigma around, boys and men being sexually abused. Also they might think like, oh, is that anything gay or things like that, so that's another added layer.
Good point. So yeah, and we're talking about the why, stigma, maybe they're embarrassed or they feel guilty or they are afraid that maybe they'll get in trouble. Maybe someone's going to hold it against them for not telling them right away. Maybe someone won't believe them. Maybe they won't be believed or didn't tell when they had the chance. They think that the chance is gone now. So when a child doesn't tell right away, what do you think happens to any physical evidence that might have existed of whatever happened? What happens to the physical evidence? 17. Right. Yeah. People go about their lives and there's a reason why, when there's a crime reported, the police, they show up with that crime scene van and they get out there, they gather the evidence, and there's procedures for that. And evidence that's not preserved may not necessarily always be available. Let's talk a little bit about, so when you have adults and you have kids and they're interacting with each other, what's the balance of power between the adult and the child? Who usually has the power? Number 3, the adult, right? The kid usually is submissive. If they're told to do something, they often will do as they're told. Kid can be told, oh, you're going to get in trouble if you do this, that, and the other. And they can be coerced that way a little differently than an adult can. So I think it's important when we're looking at cases like this to consider the balance of power, to consider the child and the position they're in, and some of these considerations about why it would be difficult for them to even speak up about it. And this is not a trick question, but are there any innocent reasons why an adult would engage in a sexual relationship with a child in 60?
I would say the only thing I could think of would be like if they were 18 and 16 and a half. Like,
Okay, so like a
you know,
Romeo and Juliet.
right, like a senior in high school and his girlfriend who's an early junior or something, like if the
Okay.
age was really, really close.
Okay, 56.
Say only in the case of the adults.
Okay. Okay. Anyone, 25?
Yeah, I was just going to reiterate what she said, because when they're younger, actually, 2 people that were in a relationship, they turned 18, they were still in.
The other person was
still young.
close in age, but
Close in age,
just
but-
under the
right.
threshold.
All right, so everyone, y'all gonna have to remember to talk one at a time. I know it's sometimes it gets to be conversational, but the court reporter cannot take down 2 people talking at once.
Sorry about that. That was my fault. So 37. Okay. Thank you for everybody's opinions. Would you, so like, there's younger children, there's older children, but older children are still children. We're talking under 17 years old here. Would you trust your older child to have their own credit card? Let's see a show of cards. Who would trust their younger, their under 17 child to have a credit card? Show of cards. 13, 15, 4, 3, 4, 6, 15, 25, 30, 31, 32, did you get 13? Okay, 38, 39, 44, 45, 34, 48, 49, 54, 55, 56, 60, 63, 66, 68, 69, 74. And who trusts the older child to come and go any hour of the night, no curfew? No curfew for the 16-year-old. Nobody. Do your taxes. Who wants the 16-year-old to do the taxes? It's easy. TurboTax, you just plug it in, it's easy. All right, so 25, 16-year-olds doing 25's taxes. So yeah, I mean, this is just to demonstrate, there's some things that, maybe you trust a kid to do, but an older kid, there's still some, just because they're older doesn't mean they're not a kid anymore. They're not an adult. You'd still, what about decisions about cosmetic surgery? No cosmetic surgery for 16-year-olds. Well, at least we've established that. So does anybody say that's a child's behavior could justify sexual abuse or sexual assault? The way that the child's acting, maybe the way that the child is dressed, anything like that. And we're getting a lot of no's. So we will move on. And let's talk about, like, does child sexual abuse only happen to one gender. I think we've touched on that earlier. Is there anyone here who, if you heard that the child sexual abuse happened to a boy, you would think it were less serious than if the same abuse happened to a girl? Is there anybody here who would see it that way? Okay. Now let's talk about what evidence you should expect to see in a case like this. Who chooses the time and the place when a child is abused sexually, touched inappropriately? Who chooses when and where that happens? The child or the person doing the touching? 21. Okay, so when someone is making a decision of when and where something like that's going to take place, are they doing it normally in front of other people who can witness it? 18, what do you think? Are they doing it in front of places where there's going to be cameras? Okay. So generally, you're going to have the person who did it and the person who it happened to, right? So you're probably going to have, to the extent that you have an eyewitness, you're going to have one witness. Is there anybody here who can't, who I guess would need more than one witness? Okay. Now, in order to kind of talk about, what happened to them and illustrate it for the jury, there'll be experts. So you're going to get perhaps eyewitness testimony, some expert witness testimony, some police witness testimony. You may hear from what's called a SANE nurse. It's a special type of nurse that examines somebody who is making an outcry about sexual abuse. They're specially trained. You may hear from what's called a forensic examiner, a forensic interviewer, who would, their job is to talk to the person who's making the outcry and to ask questions that aren't leading, to try to get out of them kind of what happened. 71, do you have a question?
Yeah, I just wanted to clarify for the people that
Sure.
didn't know what SANE was.
Yes.
It's a sexual assault nurse examiner.
Thank you so much for doing that. And so, yes, that's what the acronym stands for. That's why they call it. It's not a reference to the sanity of the nurse. The nurse is, you always want to say nurse, but this is a special kind of nurse that's called a SANE nurse. So yeah, these are the types of witnesses you're going to hear from. And that's the type of evidence you should expect to see in a case like this. What's not evidence? Generally, like most hearsay is going to be not considered evidence. The police reports for a particular case, while I can say in almost every criminal trial I've ever done, the jury does want to see the police reports in the back when they're deliberating. We can't send those back. There's just too much hearsay in them. And so the reliability of hearsay is why we don't allow the jury to take that back with them. And so for that same reason, recorded out of court statements. So if there's any interviews that took place on camera and that witness isn't going to be here to talk to you, then they're recorded out of court statements, not going to come in and you're not going to see it. To the extent that there are any prior bad acts by the defendant, those aren't relevant to this case and they will not be discussed. And no, this is not me confirming, or this is not saying yes or no whether they even exist. They just don't get discussed. So the next thing, police officers. So I did mention there will be some police officers giving testimony, and it's everybody is allowed to have their own opinion here in the world, and we've seen in the media negative things, and it's possible that some people might have a negative opinion of law enforcement. So my question would be, will anyone not believe somebody just because they're a police officer, just because they're in law enforcement? Anybody feel that way? Is anybody, well, before I ask that, would anybody not just like not believe them, but would you maybe like believe them a little bit less? Like you're not going to just completely disbelieve them, whatever they say, but you just put them maybe a step down from a normal witness. Anybody think that way? And maybe the opposite. Does anybody put a police officer a step up because they're a police officer? Okay, so y'all will, everybody will consider a police officer's testimony the same as any other witness. 41, yes. Yes.
We're talking police officers, just the first person on the scene, or somebody's the specialist?
Well, there could be some of each. So sometimes a police officer will arrive to the scene because they're the patrol officer who's dispatched. And then, when they figure out why they're there, they may have to pass it on to a follow-up unit. So there could be people, either a patrolman or a follow-up detective. And so that's the situation. And has anybody ever had a negative experience with the police officer? And I'm not going to ask you to tell me what it was, so you can just raise your card. So let's go down the list. 3, 6, 7, 8, 11, 15, 17, 25, 26, 30, 31, 36, 37, 42, 45, 46, 48, 50, 51, 53, 68, 58, 63, 67, 71, and 74. Now, for those of you who raised your cards, did we get 51? Okay, good. All right.
The previous question.
Yes. Yes.
Depending on the type of situation.
Okay, I'm so sorry. Court reporter cannot hear.
I said, depending personally for myself, depending on the incident, my opinion of the police officer may be lesser than somebody else, depending on the circumstance.
Thank you for letting me know. Anyone else have something to add in that vein? 15? Okay, that's perfectly all right. So for anybody who raised their card about having a negative experience, who, because of that negative experience, thinks they would not be able to be fair in this case? Does anybody think because of the negative experience with the law enforcement, I can't be fair to the law enforcement witnesses? And we have number 42, 50, 63, 67, and 15. Are you saying, okay. Well, I technically need a yes or a no answer.
Yes.
Okay, we'll put you on that list. So, is there anyone who would feel uncomfortable believing the testimony of a police officer witness? Which I guess I've kind of already asked that, but we'll move on. So it's your job. While we're talking about police officer witnesses, it's going to be your job, if you make it onto the 12-person jury in this case, to judge the credibility of the witnesses that go on the stand in front of you. So you guys have interacted with people in life. I think, do y'all have a good, who thinks they can spot a liar? 13. All right. So what sort of things do you look for when you're concerned someone might be lying to you? Their body movement. What about their body movement looks off?
They're not fidgeting all the time, they're not sweating, so on and so forth. So with me, it's kind of just I study how to interact and then go.
And how did you come by this ability?
Experience.
Right, like your life.
Yeah,
Right?
real life experience. Working in psychology.
So we'll talk about like common sense. You said body language, facial expressions. You might think about like what's corroborated. We may not have a video camera of that night, but who's telling a story that is getting corroborated by the evidence, the other physical evidence that you may have? Who has a reason to lie? Like, I mean, y'all are here today. These cases, they take quite a while to build up. There's investigation. First they have to make their outcry. Then they've got to go see these various experts, the sane nurse, the forensic interviewer. They tell the story again and again. And, that's, it can take years of their life where they're talking about this terrible thing that happened to them. And I guess maybe I'll illustrate it. Who here, and you can raise your card, wants to tell the room about your first sexual experience? First time you had sex? Anybody? No, right? That's not something people will even want to do. And now imagine your first sexual experience was not consensual. And now you have to go up and you've got to tell that story to this room full of people you don't know. Most people don't really have a motive to go up and do that if it's not something that actually happened to them. And even when it did happen to them, it's not a fun thing to do. So let me ask, who here has a close friend or a family member or yourself, do you know that's been a victim of sexual assault or sexual abuse? And I will.
5 minutes.
Thank you, Governor. 1, 3, 4, 7, 10, 13, 14, 15, 17, 18, 20, 21, 22, 23, 24, 25, 26, 27, 28, 30, 31, 32.
Travis, can you speak up, please? Your face.
Sorry. 36, 37, 39. Did we get 11? 40, 41, 35, 42, 43, 45, 46, 47, 49, sorry, 48, not 47, scratch out 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 60, 59, 62, 63, 64, 67, 68, 71, 73, 74, and 75. For those of you who raised your cards, who, when considering that, cannot be fair in this case? 3, 4, 10. Are you raising?
Excuse me. That's not the appropriate question. So everyone who answered the last question, the question is whether or not, if you were selected on this jury, would you be able to listen to the evidence and base your decision of whether he is guilty or not guilty? Because as I stated before, we all have things in our past, but each side is looking for a fair jury. So the question is whether or not, if you were selected on this jury, would you be able to listen to the evidence and base your decision on this case, whether someone is guilty or not guilty based upon what you hear? Does everyone understand the question? All right. So is there anyone here who would not be able to base their decision on whether someone is guilty or not guilty based upon the evidence that's brought to you and the evidence that you hear? If there is anyone who cannot do that, raise your card.
3, 4, 18, 23.
Okay, you're whispering. She can't hear.
18, 23, 25, 26, 32, 37, 39, 41, 42, 45, 46, 50, 53, 54, 55, 63, 65, and 67. All right, and now we're going to talk punishment. They did say that in the event that the defendant is found guilty, they would go to the jury for punishment. So I just want to go over that briefly. The judge did mention it's a 2 to 20 year term. It's up to a $10,000 fine. This is a second-degree felony. And so I think she asked, and she got everyone to say that y'all would, and we're talking about considering now, consider the full range of punishment. You guys don't know the facts yet. Y'all don't know exactly what went on, what the allegation is. So I am going to assume that your answer is going to remain the same, that you can consider, at least consider the full range, 2 to 20 years of punishment in this case. And number 60, do you have a question?
Does it also require like state registry and?
It would be a lifetime sex offender registry with a conviction for this type of case. Number 25.
So I have a question about that. So what if you feel that 20 years is not enough? Is that?
Well, we're just asking, right, if you can consider this range, if you understand that that's the legal range for that you're allowed to consider, and that you would then consider that in deliberations, yes.
All
Number
right.
6.
So whatever the law says.
Right, so you're saying you
That's
follow the
what I
law. And that's basically what we're asking, is just if everyone here will follow the law.
All right,
And-
state your time has expired.
Okay, thank you. Your Honor.
All right, does anyone need a break? All right. Yes. During this part? No, what I always encourage everyone is just listen to the attorneys. If there's something that you feel you need an explanation of, now's the time to ask. All right. All right, thank you.
Did he state that the report by the officers that first get to the scene not be allowed to be seen out there?
All right, so everyone, when the state was speaking, they're speaking about hypotheticals. They're not allowed to give you what they think the facts are in a case, because if you can imagine, in different cases, everybody has their idea of what they think the facts are. So they're not allowed to give you the facts. Now, in criminal cases, witnesses are supposed to come and testify. Usually, hearsay statements are not allowed in. For example, a police report. An officer may come to testify. And when they come to testify, they may try to remember dates, but they wrote a police report and somebody will ask them, hey, if you look at your police report, would that help you remember, what the case is about, or where did you go, or the address you went to? They then can look at that police report and say, okay, I remember this now. This is the address I went to, and this is the date I went to. Many times jurors, when they're deliberating, they will ask for, hey, let me see a copy of that police report. That's what they mean by hearsay. That police report is usually not entered into evidence. So the testimony that you hear is what you're allowed to consider. The police report usually doesn't go back with you. And there are other statements that people may have written that won't go back with you because it's considered to be hearsay. Does that answer your question? Oh, well, what part?
Well, if he's there on the scene and he's, interviewing you. And it's good time there, he's writing everything down, it's like our here.
Mhm.
Why that's not allowable?
All right, it's not allowed because when people write police reports, it's assumed that you're writing that police report because there is alleged to have been a criminal offense. So it's something that's specifically made for trial or made to be used in a court of law. And so what our law says is the best evidence for you is to have that person come in and testify. Because imagine if you were going to allow police reports into evidence and just people's statements in the evidence, you wouldn't need any witnesses. Everybody would just say, here's the written report. Tell us what you think. The reason why witnesses are called is because you can look at them and you can make a determination of if they're telling the truth or not. It's sort of like when I was in college and you had to write a paper and you're writing that paper and that paper's great and you're saying you did the research without anybody talking to you. That's completely different from a court of law, because jurors are supposed to be able to look at a person, make a determination if they're telling the truth. Does that clear that up? I hope it does. Sort of, kind of. All right. All right, defense, are you ready to proceed?
Yes, Your Honor.
All right, you may proceed.
Thank you. Good morning, almost afternoon. Again, my name is Matthew Allen, along with Ruben Pizania, represent Raymond Alejandro. And so I'm going to go over some of the same topics and subjects that you've heard. I'm sure at this point you're like, just move on with the process, but they are so important to make sure that we get a fair trial in this case for both sides. Sometimes when I talk about it a little bit differently, it sparks something new. Other times it may not. So if it doesn't, I'll try to move on. But jury service. So is this the right case for you? And I'm sure most of you or all of you are saying, no, this one's not good. Fine. But really what we're talking about is what Judge Boyd and the state have been talking about is, can you be fair and impartial in this case? Can you judge this case just by the witnesses that testify? And your prior experiences are not going to impact your verdict. Again, you can use your common sense, but we just want to make sure we start out at a fair basis. So the duty to serve and the duty not to serve. Well, the duty to serve, each of you have done that through yesterday and showing up again today. You are all doing your duty to serve, because it may seem like, well, can't you just get 12 or 15 people? But you've already seen a lot of people have experiences or something else going on that this may not be the right case for you. So the duty not to serve, some of you have already done that by saying, look, this isn't the right case for me. If it was a theft case, if it was just an assault, a fight, I could do that. I could be fair and impartial, but because of this type of case, I can't. And that's all we're really trying to figure out. So who here is biased? So if I just said, who here is biased? I'm sure all of you would say, no, I'm not, I'm fair, right? Now, can anyone tell me what this is? Okay, juror number 63, he said a cat. Juror number 45? Perfect. Somehow I always get a Packers fan on my panels, but are you a Cowboys fan, sir?
My wife.
Okay.
Well,
So-
I guess I am too.
Yeah. So again, as a Packers fan, if you were on a jury to decide, should this be a catch or not be a catch, you think you might have a little bias?
I would, yes.
Okay, so you think maybe that may not be the right one to decide, you to decide, right? Okay, and that's all we're trying to figure out here. So a lot of you may not care about football, or you may not be a Cowboys, you may hate the Cowboys and Packers. So you may be fine to decide that. So that's all we're really trying to find out here. Presumption of innocence. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. So what that means is that sitting here right now, he's presumed 100% innocent. Now, is there anyone that came in here and when they heard, at least you knew it was going to be a criminal case, sat down and thought, man, I wonder what he did? And you can be honest. Anyone? Okay, that's fine. Juror number 3, is that, you kind of thought that?
Like, what's going on?
Right,
What
right.
can you do?
And that's normal. But what the law says and what the judge is going to instruct you is that you have to presume him to be 100% innocent unless the state can prove all of those elements beyond a reasonable doubt. So sometimes we say, well, when there's smoke, there's fire. If you're here, you must have done something wrong. Now, is there, again, could you raise your cards if you were thinking that at any point? And it's okay. If you could raise your cards again. Juror number 3, 11, 4, 13, 17, 20, 23, 25, 27, 28, 30 through 32, 34, 37, 41, 42, 45, 49 through 51, 54 through 56, 62 through 64, and 67. Okay, now for those of you, again, so some people strongly feel if someone's been charged, then they must be guilty. So for those of you that raise your cards, or even if you didn't, is there any one of you that is saying, look, I understand that that's the law, but I just can't follow that. I just cannot presume him to be 100% innocent. I can get to 95% or 96%, but I can't presume 100% innocence. Is there anyone in here that feels that way, that cannot presume him to be 100% innocent? Okay, jurors 3, 4, 16, 18, 23, 37, 42, 50, 58, 59, 63, 65, and 66. Thank you. Again, that's the law, and again, and we need jurors that can make sure to follow that law. But that's the great thing about living in the United States is you can say, I don't agree with that, and I just can't follow that. And that's fine. And you guys didn't get arrested, your seats don't come out from under you. All we're trying to figure out is, can you do that? So indecency with the child, the state again went over it, engaging in sexual contact with the child. So again, and some of you have already said this and said, look, that type of case, whether it's because of it's a child or a sexual nature of the offense, I can't be fair and impartial in that. So again, is it the right case for you? We already answered that, so I'm not gonna go through that again. I am gonna ask it a little bit differently. Have yourself, a loved one, or a friend been accused of sexually assaulting a person, whether it's a child or adult? Okay. Jurors 9, 4, 13, 15, 20, 26, 30, 35, 39 through 42, 45, 51, 53, 54, 63, 65, 71, 74, 75. Yes, sir.
Okay, I was gonna say that, one of my best friends, my wife's best friend has been wrongfully accused of. And served, 15 years in jail.
So you had, you or I guess your wife's,
My wife's best friend.
your wife's best friend was accused and
And in prison for 15 years.
served 15 years, but they were wrongfully
Correct.
accused.
I don't think I'm right for this.
Great, and I appreciate you letting us know. And I should have mentioned this, if you think like something's important, but you just don't want to say it in front of 74 other people, you can let us know, but I definitely appreciate that. And again, that's what we're trying to find out. Yes, juror 15.
Yes, I also. Why I've been unsure about.
Okay, and I think you had told the state, you know, hey, look, I'm on the fence, but I'm gonna err on the side of caution. This probably isn't right for me. Is that fair? Okay, thank you. Is there anyone else think that hasn't already said that or just raised their cards for that reason, that's saying, you know, hey, look, this isn't right for me? Yes, you're 25.
Yeah, just being a father of a young child, I mean, when I heard what the charge was, my blood started to boil, and I was like, you know, I don't know that I could be impartial.
Okay.
You know, I'd like to say I'm fair and unbiased, but
Right.
that feeling.
Right, and I think you had mentioned that before. Juror number 3.
I'm a mother of little ones. It makes me emotional to even think about it. Like I'm trying to fight tears to even think about it.
Oh, thank you. Juror 4.
Same way, had uncles be charged with sexual abuse, and I kind of feel strong about it, so I'll probably be unfit for this trial.
Okay, And so again, you know someone who's been charged with it, so like I said, it kind of, it goes on both sides here. And one of the things I wanted to mention before is this isn't a trial on which is sexual assault or indecency of a child. Should that be a crime or not? It's not that this side thinks it should be and this side thinks it shouldn't. I think we can all agree that anyone who does those things to any person, especially a child, should be charged and should face some sort of punishment. What we're here for is, again, whether the state can prove that case beyond a reasonable doubt, and that's what it is. So again, just wanted to let the jury know. So I myself, I do have 2 young children. So again, people ask me all the time, well, how do you do that? Or and it's because there are false accusations. It's because we live in this country where everyone deserves a defense, and we need to make sure that those laws are abided by and that the state actually proves what they're saying someone actually did. Is that fair? Okay. And I saw some people are counselors, but even if you wrote it on your juror card, if you could raise your hands. Has anyone ever counseled or volunteered to help victims of sexual assault or children who've been assaulted in any way? Juror 13, 17, 20, 28, 30, 31, 33, 36, 50, 59, 62, 73, and juror 32. Same thing for you guys as the follow-up. Would you be able to put that aside and judge this case based solely on the facts and the evidence that's presented to you? If there's anyone who just raised your card that says, look, because I was a counselor or I volunteered to help, I can't do that. I can't judge this case just based on the evidence presented. I'm going to have some bias because of that. If you could raise your cards again. Juror 20, 28, 32, 50, and 62. Thank you. I think we covered that one, so I'm gonna move on. Is it easy or difficult to make an accusation? Oh, I'm sorry, juror 71.
Yeah, I had a question.
Sure.
For the first question of the 2.
Okay.
I used to be a SAR peer educator, which is sexual assault relationship violence. So I don't know if that answers that first question, but to the second question, it doesn't advise.
Okay, thank you. I appreciate you clarifying. Is it easy or difficult to make an accusation? Anyone? Juror 17? Difficult? Juror 6? Very easy. Juror 11? Easy. Juror 21? Okay, juror 26? Easy. Okay. How so, juror 26? How would it be? I mean, how easy is it? Do you know?
Well, look at my accused or, and it made me feel so sad because he wasted 22 years in jail because of that, and it was easy for that person to only accused. So that's why I believe it's easy.
Okay, juror 51. Okay. Both? Okay, yeah, I can see where you're coming from on both. Juror 56.
I think it depends on the person making the accusation and the act. I don't think, for me personally, it would be accusation.
Okay, right.
But for a person who is that type of person.
Okay, and we'll get kind of touch on some of those things. Juror 49.
It's depending on the ethical values of that individual making the accusation.
And we're talking about ethical values, a type of person with children. Do we always know? Is it different than a 10-year-old and a 35-year-old? You've got different world views and experiences. Juror 59.
So feel that it depends on like the situation that they're in, like is there background to it, has there been background to evolve that, like is there arguments that happened before and now this is coming up? So I feel like there's more information that needs to be.
Okay. Juror 40.
It's easy and difficult to sometimes think about it, depending on a child's age or depending on how old the kid is, they don't look at it as like for the consequences or accusation that you're giving. So it can be fairly easy, but at the same time, you know, if it's something an accusation, if it is true, it's really difficult for a child to move forward on that. Whereas with adults, probably the same thing a bit easier because they have had more experience.
I think that's a good explanation. Thank you. Juror 36.
Trying to take everything on and listen, I think a lot of times the accusations are usually made by the person that they cried out to. Either, you know, they reported it to a teacher, they reported it to the school nurse, they reported it to their parents. I've had parents of students that have accused another parent of doing something and have told me about it. Being very uncomfortable. That accusation sometimes not going to come directly from the child. They're just going to report it to the adult. The adult then takes it to where it needs to go.
Yeah, so I guess yours, an accusation to, is it an accusation to anyone, an accusation to the police, where a child may not say, okay, I'm gonna go to the police to make an accusation. They may just tell a parent or somebody. Juror number 24.
For me, I think it was difficult with a child because of the intimidation factor. What has the perpetrator told the child would happen to them for their family, for them to, if they came forward with it?
Sure, there could be threats. It could be difficult. So let me go as far as, well, how would you defend yourself? Or if you don't want to think of yourself in that situation, a loved one or a very close friend, how would you tell them to defend themselves against an accusation? Juror 62.
To have an alibi?
Okay. Okay, so yeah, if that's possible, that would be good. I mean, if you don't have an alibi, juror 40.
Parent, the child is definitely start to let them know that secrets aren't something that is adults, children, there shouldn't be any kind of, you know, hey, don't tell your mom because it's a secret, or don't tell so and so because it can get you in trouble. There, you should definitely start early with that kind of stuff with little kids, so you know that secrets aren't okay, things like that's not okay. It's important that you know, and you should be talking to someone about it. So.
Okay, yeah, that's I guess a different way of defending yourself. Well, I guess the way I'm asking is how would you defend yourself against an accusation? If a person, and no, but I understand what you're saying and I agree. So, and my question wasn't clear, so I do appreciate that. Juror 45.
Well, obviously, voicemails, good shot, wherever you can to protect yourself.
Okay, juror 31.
I would ask for an investigation, like go out and ask people, investigate, you know,
Right, juror 33.
or I would establish if I even had a relationship.
Okay. Juror 51.
Yeah, right.
Get an attorney. Okay. Juror 6.
Witness and facts.
Witnesses, facts. Okay, would you hire a lawyer? Right, would you, juror 71?
Yeah, I don't know if polygraphs hold in the state, you know, in court, but if I had to prove myself by myself, I would take a polygraph test.
Okay, so I'll just tell you, polygraphs are not admissible in court, but that is something that people can do. Would you want that lawyer to question all of the witnesses that come forward? Right? What about if it's a child? Would you tell your lawyer, look, it's a kid, so I don't want you to ask them any questions? Or would you want your attorney to ask questions to try to get to the bottom of it? Juror 40? Okay, yeah, juror 21.
Proving my innocence is far more than emotion.
Okay. Juror 33.
Yeah, we don't know the age of the child, if they even developmentally can do that and whether.
Okay. Juror 11.
I would want the lawyer to hire somebody to evaluate that child at that time. If you just ask the child a question, they might get intimidated by you.
Mhm.
But somebody, after there is something that they hire to kind of get that story or even find it from
Well, yeah, I guess what I'm saying, if someone's gonna come testify against you, would you want your attorney to ask them questions?
Again, I would hire that person to ask the right question.
Yeah. Sure. Sure, no, I understand. Juror number 9.
If I'm putting myself in a position where I'm wrongfully accused, and I'm hiring an attorney, I would absolutely ask them to put anybody they feel comfortable, regardless of their age, on the stand to speak up the truth.
Juror 6. Same answer. Juror 25.
So, having been interrogated by a lawyer before, and it's not a pleasant experience, I would definitely, if I'm thinking about my own child, even if he was a witness, I would want to know the line of questioning. And yeah, I would want to know, because, you know, I may, like this gentleman said, I may want a third party instead, because
Juror 60.
Would it be possible, like, if you were in that situation to like ask for like a court appointed advocate, like a CASA person to be there during the questioning?
For
Like, if you were going to question a child, would they be able to have someone there to support them?
there's usually, it just depends. I don't want to get too deep into it. If someone's gonna be a witness, they may not be able to sit in here the entire time. But it's an open courtroom, so if someone is not gonna be a witness, then other people are invited in. Juror 63.
I would love to get everybody involved, like you're saying, like what he said also, but you gotta keep in mind also the kids could be coached to say something that's not true.
Juror 51.
Yes.
Right, okay. So, would you expect the police to conduct a full investigation? Right. And would you want to hear from all the witnesses? Okay. Would you expect some corroboration from what witnesses they're testifying about? So overall, when we've been kind of talking about it, I know it's uncomfortable to put yourselves in that situation or someone that you're close to. And some of you unfortunately have experiences where you know someone. But again, do you think it'd be easy, or could it be difficult to defend yourself against an allegation if someone says something? Or 18?
It would be difficult if. It would be difficult if.
that'd be difficult, to defend yourself.
Mhm.
You have to convince all people.
And the state brought up, okay, well, you don't pick who's around or if there's cameras or anything like that. So again, if there's just two people, one person's making an accusation, one person saying it didn't happen, can that be difficult to say for the person saying, no, it didn't happen? Right? We may not have text messages or an alibi. I was in Florida on vacation with all of you guys next week, but juror 56.
Is really defending himself if the state has the burden of proof?
Yeah, that's a good point. So again, I'm glad you brought that up. So the state is the one that has to bring the proof against you. So, and we'll, perfect segue. The burden of proof is on the state. So that, like Judge Boyd said, the defense does not have to do anything or produce anything. Whether it's because we don't believe that the state proves that case, whether it's because there is no extrinsic evidence like a text message or an alibi or anything like that. Is there anyone that says, look, that's not okay with me? The defense should have some burden. It's just too much for the state. No? Okay. Beyond a reasonable doubt, like I said,
You have to. I say you have to defend them.
well,
Because I mean, in my experiences, they didn't do their job right.
Right, and so like Judge Boyd said, look, we're not gonna sit here and watch Netflix and do things. I'm sure you'll hear from me more often than you would like, but just to get that concept across that, again, that burden is on the state. So beyond a reasonable doubt. So again, there's no definition, so it's gonna be up to each of you what that means to you. But as Judge Boyd talked about, there's different burdens, and I'm not gonna try to get too close, but on the far wall over here, we have no evidence at all, okay? Most of us have, I think, been pulled over before. I've been pulled over, unfortunately, more than once. But reasonable suspicion, that's what an officer needs to just pull you over. How many of you heard probable cause? What can an officer do with probable cause? Does anyone know? You're 17?
They can search your car.
Search your car. Okay, so they can get a search warrant, come into your home, search your car, and they can make an arrest. And that's probable cause, okay? Now, I see some of you have been on civil juries before. So when you're talking about money, damages, it's preponderance of the evidence. So it's 50.001%. Okay, that's a civil jury. Jurors in the first 12, how many of you have children? Okay, I think you guys have expressed this, so tell me how much evidence you'd want the state to have if they were gonna try to take your children. Juror 6?
All of it.
All of it? Okay, juror 4?
Same.
Same? 3?
And then some.
And then some. I think we can all agree that's a serious accusation to make to take someone's children home. And so that's what we call clear and convincing evidence. A firm conviction in the truth of the matter asserted. And so that's here. And then we go to beyond a reasonable doubt. And so we're all the way at this end of the wall. So I can't tell you what beyond a reasonable doubt means, but those are the burdens of proof that lead up to it. Why do you guys think that in a criminal case, the burden is so high? Why is it the highest burden that we have? Juror 60?
I mean, we're talking about 2 to 20 years of someone's life and then having to register after that. So
Right.
that's a huge deal.
Right, juror 50, 51?
Jail time.
Jail time. We're talking about, yeah, juror 24?
Reputation.
Reputation. We talked about impacting families. It's the highest burden because we're talking about someone's life. We're talking about someone's liberty. Okay. Should the burden of proof be less because a criminal offense involves a child? Does anyone think that? Look, I agree with that for maybe a theft case or something, but if there's a kid, the burden, that's too high. Okay. Is there anyone that would not require the state to prove each and every element beyond a reasonable doubt? If you're on this jury, okay? 3 possibilities: not guilty, guilty, and I don't know. If after you hear all of the evidence and you're back in that jury deliberation room and you're thinking there, or between the 12 of you, you're going, look, we don't know. What does your verdict have to be? Who said not guilty? Why does it have to be not guilty? What does that mean if you don't know?
Reasonable doubt.
Juror 11? Not enough evidence. Juror 4?
Reasonable doubt.
Reasonable doubt. Okay, so I'm gonna ask it again. If you're back there and you're thinking, man, maybe it happened, or maybe it happened a different way, or possibly, or probably, again, that doesn't get you to beyond a reasonable doubt. And if you're back there and you say, I don't know, they didn't take me to that point where it's beyond a reasonable doubt, what does your verdict have to be? What would be some reasons to accuse somebody of this type of offense? Juror 6.
Be very little reasons and that's the age.
Okay, and look, they committed the act, that's one reason. Revenge, you want them out of your life, to seek some sort of attention. There may be something else going on. I think juror number 6 said it perfect. There's a lot of different reasons. And I guess based on that, there's a lot of different reasons, and I'll get into that. Would it be easy or difficult to recant, to take back? So you make an accusation, whether it's to a parent, a friend, the police. Would it be easy or difficult to maybe take that back? You can't, juror number 58.
Because once it's already been said, it's already been said.
Okay, juror 56.
I think it depends on how far in the process. So if it's just in the beginning and then, you know, us really, you know, a few were on the rest of the trial starting, it's might be easier. But once you get to trial and so many things involved, it might be.
So yeah, it depends on where you're at, juror 21.
Process of detecting this, the damage is done, significant damage can vary based on that's the truth.
Okay, juror 33.
It depends on who it's being reported to, so as a healthcare professional, I know it's quite happy. Others.
Right, okay, it depends on who it is. So again, oh, I'm sorry.
Oh, I was just gonna say, most human beings would have difficulty after falsely accusing somebody. We can't.
So I think we talked about it. Look, the ball is rolling too far downhill. You know, we're too far into the process. I said it, and now things are happening really fast. What about, do people, even adults, but do children always understand the consequences of what that accusation is gonna be? Right? Anyone think that maybe, and again, I know it's gonna be age dependent, but juror 6?
Yes.
Okay. Okay. And you may not understand what those consequences are. Again, didn't understand the ramifications of it. And so once someone, a child or an adult, starts seeing that, if you're a child and you tell something that's not true, and now all of these things are happening, and it's happening really quickly, you might get in trouble if you say, oh, well, that actually didn't happen. You think that can happen? Do children ever lie about something important? Yeah. Even sexual assault? Do you think children ever lie about that? Yeah.
Yes.
Are you always gonna know that they're lying? Right, juror 33?
Then once the age of the child development. Depending on the age, the child is not really what that is. Try something like that.
Well,
It's not, they may not have made it up because they don't know what that is.
okay, I mean. Well, let me take it, an adult, would you always know an adult is lying about something like that? Right, okay. Can it be difficult to determine whether someone's telling the truth or not? Right? And I think we all think of our own kids, and you get to know them, and you kind of know, like I know when I'm talking to my son, if I hear my daughter crying, he comes running out, he goes, I didn't do it, right? I kind of know something's going on there. Whereas if it's someone else that I'm just meeting, can it be difficult to determine if that person is telling the truth or not?
So again, you're talking about that. However, the nature, whatever the nature of the lie, the cookies.
Mhm.
Yeah, right. So what is scenario? And looking at the developmental age of the child in this scenario, and what we hear is honestly personally or the conditions on which they've been raised. You have to take all of those factors.
Yeah, and I agree. It could be really easy. You may hear from witnesses and say, I believe what that person is saying, and I have no doubt about that. There may be witnesses where other things are happening and you may have some doubts. Does anyone believe that a child, and I know I've tried a good way to think of, or phrase this question, but is there anyone thinking that there's no way a child would ever lie about being sexually assaulted? Do we always know why someone would make an accusation? So the state talked about motive. They don't have to prove motive, and we don't have any burden at all. So would you require us to show some ulterior motive? I think we can all agree, we would like to know what it is, but are we always gonna know? Okay. Do we always know what's going on inside someone else's head? Right? Okay, so is there anyone out there saying, look, you don't show me an ulterior motive? Again, are you gonna put the burden on the defense to show some ulterior motive? The right to silence. Again, Judge Boyd talked about it. Means that a person on trial does not have to testify. They can sit there and you cannot hold that fact against them. If the person does not testify and you're a juror in the back and someone says, well, they didn't testify, then you can't allude to that fact at all. So is that okay? Is there anyone that would say, if he doesn't testify, I'm gonna hold it against him in some form or fashion? And I know the judge is gonna instruct me that I can't, but I can't follow that. I'm gonna hold it against him. Is there anyone out there thinking that? It's okay. Juror 42 and 25. Okay, and that's okay. We just need, and juror number 3. I just need to know. Jerry Seinfeld said the number 1 fear in life is public speaking. The number 2 fear is death. That means if you go to a funeral, you're better off in the casket than giving a eulogy. So he talks about public speaking. So what would be some reasons why someone wouldn't testify? $71?
Anxiety.
Okay. Anxiety. Juror number, I can't see, it's flipped around. 38? Okay, it has trouble communicating. Juror 11?
No, they can't convey what they.
Okay, juror 49?
Shane.
Shane, okay. And I think it was juror 25, you said you've been cross-examined by attorneys? Okay, would you voluntarily want to put yourself through that again?
If it came to defending my own innocence, absolutely.
Okay, well, was it difficult to testify? I think you said it was.
I didn't testify.
Oh, okay.
It was like,
Okay,
in a meeting room with.
Okay.
Both attorneys or whatever.
and so attorneys, good attorneys, like Sid, can try to twist things, right? Okay, juror 24.
Sometimes they feel like patient. They don't know how to say what they need to say.
Okay, juror 6.
Same thing, you may just end up in a debate with yourself by saying. I'm just so nervous.
Yeah, have you ever had the person that keeps trying to explain themselves and they keep sounding worse and worse as it goes on? I think one of the jurors talked about, eye contact and those types of things. I don't know if you guys have noticed, but I bite my nails and I've done it since I'm young, and then I tap my leg the entire time. So those are, I've read and experts have told me those are 2 things that you shouldn't do. So I do those. So I always say I may not make the best witness, but let me talk about the flip side. Person on trial has a right to testify in their own defense. The state talked about motive. Okay, so I mean, what do you guys think would be a motive would be for someone to testify in their own defense? Juror 9?
If innocent, nobody's gonna be more passionate about speaking about your own innocence.
Okay.
in my opinion.
Right, and as some of the jurors said, look, I would do that. Juror 41?
Connect to the person's humanity.
Okay. Give the jury a different side of than just sitting there. Juror 33? Okay, to get that other side of the story out. Would you automatically disbelieve that person? right? Would you automatically say, look, that guy's gonna get up there and say whatever he's got to get himself out of this? So the state talked about police officers. Would you automatically believe a police officer or not believe a police officer? So the way it works is every witness starts out on the same level, okay? Whether it's a police officer, whether it's a person accused, child, they all start up at the same level. Now, after they start
5
testifying,
minutes.
thank you, Judge. After they start testifying, you can, obviously, you weigh that against the other evidence and testimony, and you can go up and down. But is there anyone that, if he decides to testify, would automatically start him below any of the other witnesses? Juror 42? Thank you. Anyone else? Okay. We talked about that. Jury's job. You're the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given to the testimony. Judge Boyd is going to give you the law, so you don't need to memorize the law. Judge Boyd will give you that, but you're the exclusive judges of the facts. Okay? Is there such thing as a human lie detector? No? I mean, is it possible for reasonable people to disagree on what they believe happened? Speculation, assumptions, guesswork, and filling in the gaps. The state has the burden of proof. They have to bring you evidence, not guessing or speculating or, okay, well, I know you wish you had that, but don't worry about it. The only thing you can fill those gaps in when you're in that back room saying, I wish I had, is the presumption of innocence. Does that make sense? Range of punishment. I don't know if we cover possibility of probation of no prior felony conviction. So I know you guys have answered about the 2 to 20, so I'm just gonna restrict it to if you're on the jury and if you find someone guilty of indecency to a child. I can't give you the facts, I can't give you the ages, but, and the judge instructs you that you can consider probation. I'm not asking, will you give probation? I'm asking, can you consider probation? So is there anyone out there that under no circumstances you would not be able to consider probation in this type of case? Jurors 3, 4, 10.
Just a second.
Okay.
I'm apologize you. So when he says consider probation, again, it's not give probation. So for example, can you think of a scenario in your head where maybe you would find somebody guilty, but you would give them probation? You heard people mention about the ages and the different age range of people. Does everybody understand? So it could be someone who may be 19 and the person may be 14, or it could be somebody who's 21. These are all scenarios. So sometimes when both the state and defenses are asking you about the range of punishment and whether you not consider it, people, even though I tell people it's not about this specific case, people tend to think about it. Sometimes people will look at the defendant and say, well, I'm looking at this defendant and this defendant doesn't look like they're 19. But again, remember, these are hypotheticals. So, for example, with regards to probation, if it's a 19-year-old and a child, would you be able to consider probation? And again, it's not giving it, it's whether or not you would consider it. Does everyone understand? So these are different scenarios that maybe you can think of in your head where maybe you would consider giving it. You can think of whatever fact scenario you want to think of where you would consider, say, oh yeah, I would consider probation in that. Or, oh yeah, I consider 2 years in that. Or, oh yeah, I would consider 20 years in that. People can always think of worst case scenarios where they could consider the full range of punishment, but people forget about other scenarios where perhaps they could consider probation or consider 2 years. Does everyone understand?
Yes.
All right, defense, you may ask your question.
Thank you. And so with all of that in mind being considered, again, not asking would you give probation, but can you consider it? So is there anyone out there that if they convict someone of this offense, indecency with a child, that could not under any circumstances consider probation? If you could raise your cards. 3, 4, 10, 23, 25, 26, 28, 37, 39, 42, 46, 50, 53, 54, 64. Thank you. Again, Judge Boyd's job, she gives you the law, the court's charge. Criminal trial is not a popularity contest. It's not, do you feel bad for this side or do you feel bad for the person testifying? It's about evidence in the case. Okay, and that's why we keep asking, can you consider or can you judge this case based on the evidence and testimony? Is something true just because the government says it is? Okay. Again, this is an accusation being brought to court. Is the government saying you did something? Proving it is why we're here. This is the last question I've got. I'm sure you're tired of hearing me talk. Is anyone thinking if only these lawyers again had stopped talking long enough and asked the right question, they would have learned something very important about me? Anyone? Yes, juror 65.
Kind of asocial through experiences. Open, in military. Private security here in town. Oil field and truck.
I'm so sorry. Court reporter can't hear.
Just through personal experiences and adulthood between being in the military, private security here in town, working in the oil field, and now I'm in a truck driver. I've kind of given up on society. So if you're looking for somebody that really cares, I'm not that guy.
Okay. Well, I appreciate your honesty.
Thank you. All right, defense, that's your time.
Thank you. Thank you, ladies and gentlemen. Oh, Judge, you're
All right, 15.
In situations myself, where I've experienced either myself being judged by them or someone close to me where they've already made a decision and kind of manipulated the situation.
All right, thank you for letting us know. So ladies and gentlemen. All right, thank you. All right, so we're going to take our recess now. I'm going to allow you all to have your lunch break. And we take this break and I'm going to have you all back lined up outside at 1:45. At that time, you will know who's going to be on this jury, because as you can imagine, court reporter needs a break because she's been taking down everything everyone says. There are plenty of places to eat downtown. Of course, there's the cafeteria in the basement. And if you walk along the Riverwalk, there are different places. I think they've just opened up Subway. That's right across the street past the cathedral. So there are different places for you to eat. So if you all can make sure that you're lined up outside by 1:45, and I'm going to ask you all to take all of your personal belongings with you. All right, everyone, please rise.
And please leave the numbers behind.
Yes, please leave the numbers behind. They were very expensive.